Hey everyone, it's Joe Teeters again with the CTP Quick Minute video. As I said in my last video about buyer's agency, today we're going to go over the buyer's agency contract. Now, I'm going to disappear from the screen and we're actually going to go through the buyer's agency contract page by page. I'm going to give you a quick rundown of what all the paragraphs mean, and then you'll be better informed about what a buyer's agency contract is and why it's important you should sign one before you start looking at houses. So what we've done here is taken the South Carolina exclusive right to buy buyer agency contract and broken it down into much smaller, more palatable sections for us to explain in a little more detail without you getting lost through the verbiage of all the other words on the page. So here in section 1, appointment of broker. In this section, you have two blanks. The first blank would be filled with your name of the buyer. The second blank would be filled in with the name of the brokerage that your agent works for. When you sign a buyer's agency agreement, you're not only being represented by the agent that you've been working with, you're actually represented by their entire brokerage. That means their broker in charge, their legal department, their marketing department, and any other department they might have. You get the whole enchilada. This part of the paragraph also states that you will conduct all negotiations, property searches, inquiries, anything else that you might need for the property through the brokerage and not go and work with the seller directly or work with another agent. In paragraph 2, the purpose of agency describes what it is that you're looking for in this agreement. So you'll notice you have a few boxes to check: residential, commercial, industrial, vacant land, or other. A general description of your property might be noted as single-family detached home or condo or industrial building. Approximate price range will be kind of your low end to your extreme high end of what you're looking for. Your general location would be the part of town that you're looking in. Your preferred terms might be, you'll enter into this agreement if and when you find the perfect home. Now we'll move on to the next section. Paragraph 3 of the buyer's agency agreement is one of the lengthier ones in the contract, and rightfully so. It breaks down the broker's duties to the buyer. One of these first duties is to give a meaningful explanation of all the different types of agency to their buyer. In South Carolina, we have a separate form that breaks down the different types of agency. And before you enter into a buyer's agency agreement, you sign this form. Your agent should explain in detail what these are, and don't worry, we've got a video about that too. If the broker's not representing the seller, the buyer's sole interest is the broker's only focus. That means that we work for you in your behalf and with your best interests in mind. If the broker represents both sides, meaning the buyer and the seller, then the broker has to disclose that. Whether it's under designated agency or dual agency, both parties have to agree and sign another form stating that they understand the type of agency that they're involved in. If the broker represents the seller, the broker will not disclose info given in confidence to either party without the consent of the party whose information is being given. Upon termination, the broker will keep all information confidential that has been requested, either in writing or instructions from the client, except as provided under South Carolina law. If the police come a knocking, we got to be the squeaky wheel. The broker represents that they are licensed in the state, and the broker will use their best efforts to locate property as described in the contract and negotiate any offer the buyer wishes to put forth. That means low balls, that means high balls, that means any ball. We have to submit that offer to the seller, and we have to negotiate on your behalf. Paragraph 4 dives into the buyer's duties to the broker. Basically, what this paragraph states is that you're going to work exclusively with your agent by only viewing properties with your agent, only negotiating properties with your agent, and referring to your agent about any questions you receive from another real estate broker or affiliated licensee. You'll also hold the broker harmless from any liability as a result to wrongful information given by the seller, yourself, the seller's disclosure statement, any other broker. The agent that you're working with can't be held responsible for improper information given to them. It also states that the broker is indemnified against any claims, damages, or losses or expenses arising from the handling of earnest money by anyone other than the broker. So what this means is when your earnest money is deposited, it either gets deposited with an escrow agent, a broker, or a law firm, or a bank in some cases. Unless the brokerage that you're working with holds that earnest money, they're not responsible for said earnest money. Section B of this paragraph states that you're going to assist the broker and its affiliated licensees in the process of identifying, negotiating, and contracting to purchase any property. This means providing reliable information, whether it's your financials, when you can move, what you're actually looking for, anything that the broker deems necessary for the performance of this agreement. It also means that you're going to make yourself available to the broker to see properties and negotiate, answer emails, answer texts, anything that we need to get the ball rolling and keep the ball rolling. You'll also provide the broker and its affiliates the following information: the general nature and location and requirements of the desired property you're looking for, as well as a price range for that property. You also authorize your attorney to release a copy of the final settlement statement so that we can go over it and make sure that all the costs line up to what we thought they were going to when we negotiated the contract. Paragraph 5 is known as one of the favorite paragraphs of brokers because it details the compensation of the broker. Now, there's 4 different ways that brokers get paid. We're only going to concentrate on the first 2 that you see here. Most brokerages don't charge a retainer fee or a service fee. If you have a brokerage that is, make sure that you read through the finite details of what those service fees are, whether or not they're going to be added to any commissions they're getting paid or whether they're going to be deducted from commissions paid. So here in Section A of brokerage fees, most times you're going to initial next to option 2. The broker shall obtain payment from the brokerage fee out of the transaction. The broker shall be paid by the cooperating broker as stated in the multiple listing service or as agreed to by the broker and cooperating broker, or as agreed to by the broker and seller for sale by owner. When a seller puts their property in the MLS, they agree to pay a certain amount of commission. That seller's agent then lists it in the MLS and advertises a certain percentage of the total commission to cooperating brokers. In that case, if you buy a house that's on the MLS, it's stated how much of a commission the agent is going to make, and that's what they make. You don't pay any money for it. If you find yourself wanting to buy a for sale by owner, I always encourage people to let your broker talk to the owner first. A lot of times we can get you a better price on the home with better terms, and we can negotiate our commissions into the deal, letting you be fully represented by a buyer's agent. Now, if the seller doesn't want to pay a commission, option 1 is a viable option. It states that the buyer would agree to pay a percentage of the purchase price to the broker for sale by owner. It also states that if we negotiate a contract and you decide you want to get a better deal, so you fire your agent or you terminate your brokerage agreement and then go back to the seller to negotiate a better deal, if that happens, you could owe your broker a commission. Be careful when you're defaulting on contracts or terminating contracts in the interest of trying to get a better deal, because it could come back to shoot you in the foot. I always recommend that a buyer seek legal counsel when considering a default on a contract or a termination of a contract to make sure that they're not going to owe any money to anyone else should someone come after it. Section 6 of the Buyer's Agency Agreement is the term of agency. It is a timeline that the broker has the authority to act as your exclusive agent in the terms of this contract. Now, it has a start date and an end date, but don't worry, if you haven't found a home by the end date, it doesn't mean that your broker walks away. You can extend the timeline very easily or sign a whole new Buyer's Agency Agreement. The timeline is not set in stone per se if you feel as though your agent is not giving you the best service that you feel you need. In the event that your broker is not showing up for showings or isn't working in your best behalf, you could absolutely fire your broker. Now, that's a two-way street. If you're not showing up for showings or showing up late or not giving honest information, the broker can fire the client as well. But we don't worry about that with the Charleston Trident Partners because we always go above and beyond for our clients. They want to keep us around after we close. Section 7 of the Buyer's Agency Agreement is the consent to disclosed dual agency or designated agency. The first section of this paragraph, you'll notice, there you'll have an initial next to it that you've received an explanation and a brochure about the different types of agency in South Carolina. We've gone over this earlier in the paragraph, and we have a video explaining the different types of agency, so make sure to watch those. Down below that section, you have the permission to act or not to act as a dual agent. It'll be considered or it won't. Again, before entering into dual agency, it has to be given to you in writing and all parties have to agree. Down below that, you'll have the permission to act as a designated agent and whether or not it will be considered. Again, designated agent, two separate agents under the same brokerage. You still have your own personal agent looking out for your best interest, but the same broker represents both parties. Again, you can either consider them or not consider them. We'll dive more into those agencies in another video. Paragraph 8 is an understanding that the brokerage your agent works for may have other buyers under a similar buyer's agency agreement that could be interested in the same property as you. The buyer consents to the broker's representation of these other parties. However, the broker agrees not to give any confidential information about you to those other buyers or other agents. You're still represented by your agent who has your best interests alone at hand, but the broker might represent other buyers that have the same interests as you. The indemnification of broker, paragraph 9, is a promise from the buyer to the broker that they're going to disclose any other activity that they've had with an agent regarding the search or negotiations for property. If you've been under or are under a buyer's agency agreement, if you've made offers on a particular property, if you've gone under contract on another property, are all things that your buyer's agent and broker need to know. In the event that you don't tell the truth and we make an offer and go under contract and close on a property that you negotiated a contract with another agent, then you could be due any damages that my brokerages would incur based on the fact that you didn't tell us the truth. Paragraph 10, disclosure of buyer's identity / confidentiality. Basically, this paragraph states that the broker has or doesn't have your permission to disclose your identity to the property owners or third party. If you want to stay in the dark and not let people know who you are, or if you're buying under an LLC, that's fine. As long as it's within the realm of law, we can keep it secret. Paragraph 11 is the broker liability limitation. Basically, this paragraph states that if you feel as though you've been wronged by the brokerage and by any act of omission, negligence, misrepresentation, breach of contract, errors and omissions, or any other intentional or willful act, the limitation set forth in this contract states that you would only be compensated up to the amount that was received by the broker for the transaction. So if the commission was $10,000, the most you could sue for would be $10,000. Now that's the brokerage. If somebody else wronged you, you can swing for the fences. But this paragraph states that the brokerage would only be liable for that in which they received as compensation. Paragraph 12 is short and to the point and something we take very seriously: non-discrimination. There are state, local, and federal laws against the discrimination of a buyer on the basis of their race, creed, color, religion, national origin, sex, familial status, marital status, age, or disabilities. If you feel as though you've been discriminated for any of those reasons by another broker, you need to make a point to talk to somebody and have it reported, because it's something that our association, our state association, and the National Association of Realtors takes very seriously. Paragraph 13, professional counsel. If you feel as though you need a more in-depth legal explanation of this agreement or any other agreements or paperwork that you're going to sign throughout the home buying process, we advise you to seek professional counsels. I'm a real estate agent, not an attorney. I will say that many times. I'm a real estate agent, not an attorney. I can give you my opinion, but it is not sound legal advice. Secondly, paragraph 14, we have the mediation clause. If any dispute or claim arises relating to this agreement or a breach of this agreement or any other agreement that we have throughout the real estate process, our first steps are going to be to go before mediation before filing any lawsuits. This mediation clause survives for a period of 120 days after the date of closing. If it's gone beyond 120 days, then you would seek legal counsel. More than likely, we'll end up in mediation anyway, but this is to help save everyone a lot of money and a lot of time and see if we can sit down and hash things out. Paragraph 15, sex offender and criminal information, states that it is a buyer's sole responsibility to obtain data regarding criminal activity and sex offender registry in an area that they want to buy a home. It also states that no action can be brought against a broker for not obtaining this information or disclosing it to you. We want to keep you safe, and that's why we want you to contact local law enforcement, private investigators, police, or sheriff's departments to get this information, not rely on a broker to get it for you. Section 16 is the entire binding agreement. If it's in writing, it's binding. If it's not in writing, it's not. Anything you agree to, whether it be in the buyer's agency agreement, contract for sale, or any other agreement you sign, needs to be in writing. Verbal contracts do not hold weight in South Carolina. If you have any particular contingencies you want to add to the contract, you have an area here in Section 17, which you can do so. Say, for instance, you're buying your aunt's house. She called you and said, I want to sell you my house. You don't have to have an agent. Then you could have that stipulation written into the contingency section, and it would be binding. Moving to the end here, paragraph 18, facsimile and electronic means. Remember the fax machine? Not a lot of people in business use them anymore, but some of them do. This paragraph states that the parties agree that this agreement may be communicated by use of fax or other secure electronic means. It can be signed electronically, emailed, and that the initials, handwritten or typewritten modifications shall be deemed to be valid and binding upon the parties when it is delivered. Any addendums or any changes to the contract need to be initialed and subsequently need to be initialed throughout the process if a change is made after the original contract becomes effective. Paragraph 19 is something that was added in a while ago, and it's very important. We live in a very digital age, and this states that when you're viewing property, you acknowledge that you may be under both video and audio surveillance. I tell clients, just like I tell other agents, always act as if you're on camera when you're viewing another property. Don't go through their underwear drawer. Don't go through their closets. Don't pick stuff up and play with it. You're there to see the house. That's it. If you're on camera and you break something, you could be liable for the damage. Finally, this is a legally binding agreement. The buyer shall seek further assistance if the contents are not understood, which goes back to the legal counsel paragraph. The buyer and broker acknowledge receipt of a copy of this agreement, which you'll be given after it's signed, and you agree to receive communications from the broker at the email address and phone number listed. At the end here, you have your signatures. It'll be signed by the buyer as well as the broker or buyer's agent company, by the licensee, which would be your agent, and then finally initialed down at the bottom, and you're now under buyer's agency agreement. All right, so that wasn't quite a quick minute video, but we had a lot of ground to cover. If you have any questions about any sections of the contract, don't hesitate to reach out to us. I hope that you were educated enough to feel comfortable signing one of these agreements when you go out and look for homes. Now, let me disclose, we are not attorneys. I am not a lawyer. If you have any questions about the legality of these sections, I encourage you to contact your personal attorney, or you can call us and talk to our in-house legal counsel because they are attorneys. Make sure that you watch our next episode. I promise it's going to be shorter than this. Subscribe, like us everywhere on social media. We are everywhere. We look forward to seeing you next episode. Have a great one.